Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law. And this will be what we're commenting on today. Today, I want to discuss the Daniel Penny verdict. I want you to pay attention here as the reporter provides the news and listen to the noise in the background from all of the protesters protesting this verdict.
But this one, they were unanimous, not guilty. The jury deliberating for more than 24 hours across 5 days before finally reaching this verdict. Daniel Penny found not guilty on all counts. On Friday, the judge overseeing dismissed the more severe charge of second-degree manslaughter, which carried a 15-year maximum sentence after the jury was unable to reach that unanimous verdict on that count. Now, a jury of 12 New Yorkers been locked down in that courtroom, like we said, for 5 days. It was 24 hours of deliberations trying to get to that first count. Once the judge dismissed that first count, they went to the second count, and that's when they finally got this decision where he was found not guilty of criminally negligent homicide.
So for those of you who are not familiar with this particular case, Daniel Penny was a former Marine who was riding the subway in New York in 2023, and a guy by the name of Jordan Neely, who was hopped up on all kinds of chemical substances, including K2, had numerous narcotics in his system. The toxicology performed during autopsy showed that he was under the influence of all these different substances. And at the time that this all happened, there was some concern as to whether or not they could prove causation, that what Daniel Penny did actually caused his death. Now, what he did was put him into a chokehold. And a chokehold is basically um, a arm around the neck that compresses the two carotid arteries in the neck, and that shuts off blood flow to the brain, and it can cause somebody to pass out. Now, usually when you release the pressure, they come back around, and hopefully they're more docile at this point because you have them under control. The prosecution's theory was that Daniel Penny retained the pressure on the neck well past the point where it would have been reasonable. Um, in order to get to that, what had happened was this guy was assaulting different passengers on the train. He was telling people that he was going to kill them. It was enough to put the witnesses who actually came to trial and testified. They admitted they were afraid. They were quite afraid of this man, and they were afraid he was going to hurt them. One lady who had her 5-month-old child in a stroller shielded her stroller with her body so that he would not harm her child. Um, so many things went wrong. Even the mayor of New York City admitted that the police weren't there when they needed to be, and that New York has to do a better job of taking care of people who have these psychotic breaks, because they believe that's what happened with Mr. Neely. He just had a psychotic break. A psychotic break in this case produced violent and aggressive behavior. Daniel Penny, being a former Marine, being trained in how to take somebody down and hold them in a submission hold, that's what he did. Ultimately, the young man died. But when the police came, Neely had a pulse. So it's hard to make out the cause of death being what Daniel Penny did when he was still alive after the police arrived and took custody of Mr. Neely. Now, during the trial, the medical examiner came and testified that, in her opinion, that's what caused the death, was Daniel Penny holding pressure on the neck. But she could not account for why he was still alive when he was released, and she also said that she based that entirely on the video that was taken of him holding him and restraining him. Now, the problem with that, of course, is that medical examiners can consider other evidence in reaching their conclusions, but they generally have to have some kind of physical finding or medical finding that backs up that particular diagnosis, and the medical examiner didn't do that. And then during the defense's case in chief, They presented a medical examiner who said, yeah, it was the polypharmacy that did it. All these different drugs in his system are probably what claimed his life. So there was a big conflict in the evidence there. And perhaps even more disconcerting than the conflict in the evidence, when there are a lot of people who believed that Daniel Penny was a hero for stopping this violent assault on the subway train, there were a lot of people who felt that simply because he was white and the young man that he restrained was black, that it must be a racial thing. Now, lawyers have ethical rules that require us to treat people fairly and not to have or assert racist views. Under Missouri's rules, if I were to use certain words that would be inappropriate in any context, I could be sanctioned by my bar organization for that conduct, as I should be, because anytime you manifest any kind of discriminatory animus toward a group of people, you are no longer operating as a legal individual. You are operating in the domain of basically prejudice and bias. We actually have to undergo ethical training every year in systemic bias and racial bias and that sort of thing, so that we can be sure when we are representing clients that we are not advocating for or with uh, racism in our hearts or in our language or in the way we present our case. And I think that's as it should be. You know, I've gone in my 69 years from being in a town where the grade school and the high school were separate for black students and eventually seeing those integrated. And when I joined the Army, I made a lot of new friends, that people that I had never had the opportunity to talk to and growing up. And it was really an eye-opening experience and a very positive one. Um, so again, we're not supposed to do that. We're not supposed to engage in racist rhetoric. But throughout the trial, the young black woman who was trying this case continually referred to Daniel Penny as the white man. Now, there's only one reason to do that, which is to generate animus against him on the basis of his race. And that should have absolutely no place in the justice system. It shouldn't figure into any kind of verdict against a black person or a Hispanic person, and it shouldn't figure into a verdict against a white person unless that charge is a hate crime, somebody who did something to a protected person, a person protected by statute, in such a way as to reflect an animus against race. That would be, and then it would be appropriate. But in the situation where he is being tried for essentially negligent homicide, again, that should never have come into play. Now, the jury had, over the course of 4 days, deliberated for about 24 hours total, and they had come to the view that they could not decide. They were deadlocked on the issue of guilt under the more serious charge of reckless homicide. And so the judge talked to the prosecutor dismissed that charge, and the judge sent them back with an Allen charge. Now, an Allen charge, also known as a dynamite charge, is a judicial instruction given to a deadlocked jury to encourage them to continue deliberating until they reach a verdict. It's named after the U.S. Supreme Court case Allen versus United States, which is from 1896, and that case approved the use of these instructions. Under New York law, the Allen charge is used when a jury reports it's unable to reach a unanimous verdict. The judge may issue this charge to remind jurors of their duty to deliberate with the goal of reaching a consensus while emphasizing the importance of each juror considering the views of others. Also, there are other elements to the charge. First, the encouragement to deliberate further, the respect for minority views. Jurors are reminded to consider the views of their peers while maintaining their own honest convictions. It's also important, and it's crucial really, that the charge doesn't coerce jurors into abandoning their sincerely held beliefs just to achieve unanimity. The instruction should stress that the jurors should not surrender their honest opinions merely for the sake of reaching a verdict. Now, in New York, they have specific guidelines for delivering an Allen charge to ensure that it doesn't exert undue pressure on the jury. The defense here believed that the Allen charge delivered after the dismissal of the more serious charge was clearly an attempt to pressure the jury into reaching a guilty verdict on that charge. And that may very well have been the prosecutor's intent. I wouldn't say necessarily that it was the judge's intent, but that was certainly what happened in terms of allowing the charge to be dismissed and then the judge sending them back to deliberate. So they came back this morning about 10 o'clock. They worked a little while, and then they determined that he was not guilty. I think everybody has an opinion about this case, and I certainly have an opinion. I don't believe the case should ever have been brought for two really important reasons. First, he was alive when Daniel Penny let him go, and it would be pretty difficult to assert that there was some continued compression of his neck when he clearly had a pulse at the time the police officers arrived there. So that's item number one. Item number two is the autopsy and the medical examiner's opinion would appear to me to be politically motivated to sort of curry favor with the perhaps with the prosecutor's office. That sometimes happens. It's no system is perfect. I was very disturbed to see that she did not scrupulously follow the practices of forensic medicine. And that, I think, is a mark against her in this case. Now, they did have another forensic pathologist who came in and said that, very much like my cousin Vinny, what that guy said, it's all BS. I think that's pretty much what the other pathologist said about the medical examiner's opinion. The jury reached the right result. I don't think there's any doubt about that. If you have a different opinion, I'd love to hear it. Drop it in the comments down below. Like, share, subscribe if you want to. You can email me at the address above. And if you have the opportunity today in this Christmas season, please do a kindness for someone. Just some minor kindness. It would be a wonderful thing to do. Then come on back down here tomorrow. Join me at the beach. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.